Imagine this. A company takes a loan of 100 crore from a bank. The bank is satisfied. The company receives the money. The factory starts. Business begins. Everything looks perfect. But one small legal form is never filed with the registrar of companies. Years later, the company goes into liquidation. The bank walks into the courtroom believing its security is protected. But then comes the biggest shock. The liquidator says, "Sorry, your charge was never registered. Your security cannot be recognized." Can one missed filing destroy the bank's legal priority? Can a company lose its protection because of one compliance mistake? Today, we are entering one of the most practical and most important chapters of the Companies Act 2013. Chapter 6, Registration of Charges. And our journey starts with Section 77, the section that protects lenders, protects companies, protects creditors, and decides who gets priority when everything goes wrong. Welcome to the Companies Act 2013 Masterclass. I am your guide throughout this journey. By the end of this lecture, you will never forget Section 77 because we will understand not only what the law says but also why this section exists. Today, we will learn what is a charge, why every company must register a charge, which form is filed with the registrar, what are the time limits, what happens if registration is delayed, can additional time be obtained, which certificate is issued by ROC, what happens if the charge is never registered, how does the law protect creditors, what practical mistakes company secretaries make during registration. And finally, we will solve practical case studies exactly the way they appear in CS Executive and CS Professional examinations. Before understanding Section 77, let us understand the story behind this law. Suppose a company wants to borrow money. The bank agrees, but the bank asks one question: "What security are you giving me?" The company says, "Our land, our building, our plant, our machinery, our inventory, or even our undertaking." The bank agrees because it now has a legal interest over those assets. That legal interest is called a charge. But here comes the twist. Creating a charge is not enough. The entire world must know that this property is already secured. That is why Section 77 requires every company to register the particulars of the charge with the Registrar of Companies. This creates transparency. This protects lenders. And this prevents fraud. Now let us enter the law. Section 77 begins with one very important sentence. It shall be the duty of every company. Notice these words carefully. Duty of every company. This is not optional. This is a statutory obligation. Whether the charge is created in India, outside India, on tangible assets, on intangible assets, or on the whole undertaking, the company has to register the charge. The particulars must be signed by both the company and the charge holder, along with the instrument creating the charge, and filed with the registrar. Now comes the first deadline every student must remember: 30 days. Registration should normally be completed within 30 days from creation of the charge. Miss this deadline? Can the company still register? Yes. Section 77 provides additional opportunities subject to prescribed fees and conditions. Understanding these extended timelines is extremely important because many examination questions are framed around these provisions. Now think about something bigger. What if the company never registers the charge? Will the loan disappear? No. The loan still exists. The company still has to repay the money. But the registered security gets affected. Section 77, subsection 3 creates one of the biggest consequences under company law. An unregistered charge shall not be taken into account by the liquidator or any other creditor. Imagine the impact. The bank gave hundreds of crores, but because one compliance was ignored, its security may not receive the legal recognition intended under Section 77 in liquidation proceedings. Serious. This is why company secretaries and compliance officers treat charge registration as one of the highest priority compliances. Next comes another important point. Once the registrar registers the charge, a certificate of registration is issued in Form CHG2. This certificate becomes conclusive evidence that all legal requirements relating to registration have been complied with. That certificate is not just another document. It is the legal proof that protects the security interest. Throughout this masterclass, we will also understand Form CHG1, Form CHG9, Form CHG2, Form CHG3. Section 78, Section 79, Section 87. Practical filing timelines, recent amendments, and real corporate examples. Because remembering company law is easy when you understand the story behind every provision. Now I have a question for you. Suppose a company creates a charge in favor of a bank but forgets to register it with the registrar. Does the loan become invalid? Or is it only the security that gets affected? Write your answer in the comments before watching the next lecture. I personally read your answers and discuss the best ones in future videos. If you are enjoying this Companies Act 2013 masterclass, subscribe to the channel because in the coming lectures, we are going to master every important chapter of the Companies Act with practical examples, real corporate scenarios, examination tricks, and compliance insights. Now let us begin Section 77 in complete detail. Welcome to Corporate and Securities Law Compass. I am a member of the Institute of Company Secretaries of India, ICSI, and currently serve as a company secretary. The views, opinions, interpretations, and explanations shared on this channel are strictly my personal views and are provided solely for educational, academic, and informational purposes. They do not represent the views of my employer, any organization with which I am associated, any client, or the Institute of Company Secretaries of India, ICSI. The content is based on publicly available laws, rules, regulations, judicial pronouncements, and regulatory materials, or on hypothetical examples prepared for educational purposes. No confidential, proprietary, or unpublished information is used or disclosed. This channel does not provide legal, tax, financial, accounting, investment, or other professional advice. Viewers should consult qualified professionals before making any legal, business, or investment decisions. While every reasonable effort has been made to ensure accuracy, laws and regulations are subject to change. Accordingly, neither I nor this channel accepts any liability for any loss or consequences arising from reliance on the information presented. All trademarks, company names, and logos belong to their respective owners and are used only for educational, commentary, and informational purposes. Copyright. Corporate and Securities Law Compass. Navigating law with clarity. All rights reserved.